Hello, welcome to the Beyond the Bars discussion. This is our 12th conversation that we are going to go ahead with. Uh, we started this Beyond the Bars discussion. We called it Beyond the Bars because a lot of our friends are right now in prison, and more are going inside prison every passing day. There's news about one more person being arrested, one more person being put into jail, and it's going on. And what we wanted to reiterate to ourselves and to our comrades, our friends, and to every one of you around that, all these people, the political prisoners of this country, are going to prison for a reason, because they have been speaking out, because they have been fighting for justice, because they have been fighting for liberty, because they have been fighting for democracy, they have been fighting for the constitution, and all that has been criminalized in this country outrightly, and therefore one after the other they're going to prison. It started with the Bhima Koregaon case, then the Delhi riots case, the arrest of Tista Zubair. Every day there is a new arrest, and although some of them have managed to come out, we celebrated, we felt reassured. Next day there's someone else who's going inside. Now, we didn't want them just to remain as prisoners. We wanted to remain ourselves. Wanted to remind everyone else around that they are fighters. They have been fighting for the constitution, democracy. They have been speaking out, and that's why they're going inside. That's why they're being arrested. And that's why we started the Beyond the Bars discussion, to not only speak about the prisoners, about the people who have been criminalized, but also the larger fight for which they have been criminalized and for which they have been in prison. Rest assured, many of us will go to prison in the coming days. But beyond those bars, the discussion should go on. So today we have amongst us uh, Prashant Bhushan, senior advocate, and Lubhyathi Rangarajan, a lawyer and a researcher. And the topic that we wanted to discuss with all of you, in front of all of you, in this Beyond the Bars discussion, is the state of Indian judiciary right now and the pursuit of justice. It's a strange time that we are going through right now. The judiciary, it has always been a resort of hope for a lot of us, and we have had our hopes, and we have been let down by the judiciary, as like other institutes of democracy. But other but unlike other institute of democracy, this is somewhere since our independence, and even before independence, the semblance of democracy is in the functioning of the judiciary, right? Where all of us are equal in front of law, and there is a rule of law that we believe will ultimately take care of us, will ultimately take care of the democracy. And when that breaks down, we feel the worst. When sometimes a flicker of hope comes, like when Zubair got bail, all of us almost started celebrating and looked at, and celebrated the good order, and felt reassured. But at the same time, Mohammed Zubair, a fact checker, a journalist, had gone to jail and secured interim bail from the highest court of the country, from the apex court of the country. That also says about the state of judiciary, as it says about the state of democracy. The state of judiciary ultimately is not, safe in isolation. When rest of the democratic institutions work, the judiciary will also work. The Indian judiciary has a legacy. It has a legacy of passing very good orders. At times, it has gone ahead of the existing democracy, the democratic overall consciousness of the country, gone ahead of it, gone beyond it, and passed very good orders. That has strengthened democracy. It has also at times weakened democracy. But right now, when democracy itself is in peril in the country, when we are in the worst phase since our independence, we are struggling to safeguard democratic values as well as institutions. The judiciary is also not safe. But how do we fight? Well, for an ordinary citizen, ultimately our hope rests on the judiciary, and we would want uh, Prashant Bhushan, senior advocate, who inside the judiciary had fought many spectacular battles to, for the judiciary as well as for the democracy at large. And Lubhyathi will be in conversation with him to, for all of us, again, to hope, to keep hope alive, and to see how this judiciary, this hallowed institution of judiciary, is where it takes us in the coming days. So over to both of you. Thank you once again for for taking this discussion forward, and we'll really continue this beyond the bars discussion no matter what. So Lubhyathi and Prashant sir, over to both of you.
So, do you want me to begin, Lubhyathi? Okay. Thank you, Jyotsna, for that nice introduction. So, in a democracy can only work if at least basic rights of citizens are protected. So the basic rights are what are called Article 14, 19, and 21 rights. 14 is equality, 19 are all the civic rights, the right to protest, the right to gather, the right to associate, the freedom of speech, freedom of profession, move around freely in the country, etc. And then we have Article 21 rights, that the right to life and liberty, which has been expansively interpreted by the Supreme Court to mean the right to live a life of dignity. And then there are various other institutions which have also been created in order to ensure that there are free and fair elections. There is an election commission. In order to protect public funds, there is a comptroller and auditor general. In order to ensure the rule of law, there is also a police and other investigative agencies that have been set up, like CBI, Enforcement Directorate, NIA, etc. Now, but ultimately, it is the judiciary or the higher judiciary, the High Court and the Supreme Court, High Courts and the Supreme Court, which have been given not just the power but the duty to ensure that fundamental rights of all citizens are protected, to ensure that other democratic institutions function properly, to ensure that the executive and the legislature remain within the bounds of their powers. So ultimately, the duty to protect democracy in this country has been assigned to the higher judiciary. And that is why the judiciary is required to be independent of the government and the legislature, because in a way it is supposed to guard against the malfunctioning of the executive and the legislature, and it is to protect the citizens against the excesses of the executive and the legislature. Now, if we see, there are some endemic problems that we have had with the judiciary which have existed for a long time. There is a long-standing problem of access to the judiciary because the poor in this country do not have the money to engage lawyers, and without lawyers it is practically inaccessible to them, the judiciary. There is also the problem of delays. There is a huge pendency backlog and cases keep lingering for years altogether, for decades altogether without getting decided. There is also a problem of competence and corruption in the judiciary, in the sense that we have judges who are not as competent as they should be, who often decide cases wrongly because of not having adequate understanding. And there is also a good deal of corruption in the judiciary, because of which also there is gross miscarriage of justice often. These are endemic problems which the judiciary has had for a very long time. But what we are witnessing currently, if you see, to what extent has the judiciary been successful in protecting fundamental rights or in protecting democracy or in ensuring that other institutions function as they should be functioning? Then the answer, the sort of frank answer to this question would be to a very small extent. And we are seeing three kinds of problems. One is that sometimes important causes that are taken to the High Court or the Supreme Court are not getting heard and decided, like the electoral bonds case, or the petitions against the Citizenship Amendment Act, or the petitions challenging the change of status of Kashmir, etc., or many other earlier cases also, which are just not being heard. There is a second level of problem, that some of the cases which are heard are decided very incorrectly or wrongly, at least in my opinion, and in the opinion of many other astute commentators and court watchers. So, for example, the Ayodhya case, it's decided that the entire land should be given to the very people who illegally demolished the mosque and who are supposed to be facing criminal prosecution. Or take the Rafale case, which is decided on the basis of a note submitted, unsigned note submitted in a sealed cover to the Supreme Court, which is not disclosed to anybody, which contains many wrong statements of fact, and on the basis of which the court said that there is no need for any investigation in this. Or say the Birla Sahara case. I am just giving you a few examples where the income tax and the CBI, etc., had found documents from Birla and Sahara group of companies which showed huge payments running into around 40 crores being made to Mr. Modi personally during 2013, during the run up to the 2014 election campaign. And the court said that no, we cannot order any investigation on the basis of these loose papers. Or so many other cases where campaign for judicial accountability had gone to court seeking an independent investigation into the medical college scam in which the sitting Chief Justice was being investigated. We said that in order to protect the independence of the judiciary, it is essential that instead of a government-controlled agency, an SIT should be set up by the Supreme Court to investigate this. But they dismissed that and dismissed it by imposing costs of 25 lakhs on the campaign for judicial accountability. We are also witnessing now a new trend which started with Teesta Sitra, or actually started in this campaign for judicial accountability also. Then it was followed in that Haran Pandya's case, where the Center for Public Interest Litigation had filed a petition seeking a reinvestigation into Haran Pandya's case because the High Court had come to the conclusion that the Gujarat police investigation was totally botched up. They had targeted absolutely innocent people, etc. And in that, the Supreme Court, the same Justice Arun Mishra, who also imposed 25 lakh costs in the campaign for judicial accountability case, same Arun Mishra dismissed it with costs of 50,000 on the Center for Public Interest Litigation, even though there was so much evidence to suggest from the High Court judgment itself to suggest that this case needs a reinvestigation. So this new trend is where the petitioners coming to court are being penalized either by way of imposing penal costs on them, like in this recent Chhattisgarh case of Himanshu Kumar, where he went seeking an investigation into the killing of many tribal people, allegedly by the security forces, and there was so much evidence to suggest that these people were not Naxals, and therefore it was crying for an independent investigation, but the court dismissed it by imposing costs of 5 lakhs and saying that the CBI or the NIA are free to investigate the charge that Himanshu Kumar had come to court with a false petition. Same thing they did in that Zakia Jafri case against Tista Setalwad, RB Sri Kumar and others, that they not only dismissed Zakia Jafri's petition seeking an independent investigation into the involvement of senior government functionaries in the riots of in the Gujarat riots of 2001, but dismissed it by saying that these people, the petitioners and Tista Setalwad, etc., and RB Sri Kumar, need to be put in the dock and need to be prosecuted. So, what we are witnessing is a threefold failure of the Supreme Court and also of the High Courts and, of course, of the lower courts also. Failure is at the level of not being able to hear and decide important cases. Secondly, deciding many of them in such a grossly wrong and unconscionable manner. And thirdly, burdening the petitioners or seeking to prosecute the petitioners. I mean, this is a completely arbitrary jurisdiction that the Supreme Court had carved out for itself, that you can impose any amount of costs. 25 lakhs, why 25 lakhs? They could have said 25 crores. They are saying that the petitioner should be prosecuted. And the problem is that there is no appeal against the judgments of the Supreme Court. That you can only go and review, and the review goes before the same bench, etc., which is not really a practical remedy. So there is almost a criminal indictment without the remedy of even a single appeal. So these are now new problems. So the new problem now is that we are seeing a collapse of the independence of the Supreme Court. It happened to some extent during the emergency in the habeas corpus case when the Supreme Court held that even a habeas corpus is not maintainable during an emergency. Today we are seeing that collapse in multifold manner, and this collapse is happening, in my view, for three reasons. One is, of course, a reason which has existed even earlier, that is the lure of post-retirement jobs. So Arun Mishra is given chairman of NHRC, Gogoi, who decided Ayodhya, as well as Rafael, is given Raj Sabha membership. This gentleman, Mr. Khanvilkar, is retiring now on the 30th. We don't know what post-retirement job he would be given. We will see what kind of. So this is a problem that has existed even earlier. It's not a new problem. But the new problems are, one, the use of all kinds of agencies and investigative agencies to collect some material or dirt against a judge and then use that to influence him. And if that person happens to be the Chief Justice, then you virtually get control over half the judiciary, because the Chief Justice has two very important powers. One is as master of roster. He decides which case is to be heard by which bench. And when those four judges had held a press conference, four senior judges of the Supreme Court held a press conference to say that the then Chief Justice, who was at that time this Deepak Mishra, was misusing his powers as master of roster, and the immediate trigger was the assignment of the Judge Loya case to the then number 12 judge, that was Arun Mishra. And they said that this has put democracy in danger. So when you can gather something against the Chief Justice, whether it's a sexual harassment charge, as in the case of Justice Gogoi, or whether it is that medical college scam which the CBI was investigating involving the then Justice Deepak Mishra, then you can influence the Chief Justice, and then you have virtually half the judiciary under your control. Uh, the second or the third problem is the non-appointment of independent judges and the appointment of only those judges which the government likes or which the government believes either subscribe to their ideology or the ideology of the government, or would lack independence to be able to uh, robustly confront the government in important cases. So, collegium's recommendations are not being followed, appointments are not being made recommended by the collegium, even a response is not being given. The government sits over those recommendations sometimes for years altogether. Even when the government sends it back and it is unanimously reiterated, even then notifications are not being issued. Therefore, the collegium's recommendations are being frustrated, and only those judges are being appointed who are palatable to the government. By and large, this is what is happening. So, this is another way that the government has found to frustrate or to uh, encroach upon the independence of the judiciary. So, these are sort of emerging problems. So, I'll stop here, and now we can have whatever discussion with Lubhyathi.
Thank you so much for that very, very lucid laying of points on the state of the Indian judiciary. Um, Before, of course, I ask you some questions that had in my mind while you were speaking. Before this conversation, I was actually trying to mind map the state of the Indian judiciary by looking at some of the cases that have caused a lot of very strong public reactions, both at the Supreme Court and the lower judiciary. So, to my mind, I also sort of see the lower judiciary as coming into public consciousness in a very strong way, where orders of the trial court are being scrutinized, either because they are wrong or because they are taking too long, for example, to grant bail and things like that. And so in this mind mapping, there are a couple of cases of note. So, for example, the Aryan Khan case, the demolitions that happened in Delhi. So I'm just sort of pointing out certain big cases like that. So Mohammad Zubair, Tista Setalwad, Bhima Koregaon, Delhi riots. So I think there's a sort of, in the last few years, we're seeing what we're seeing really is, and I think we've seen this a lot in public as well, that people are being arrested for vague and flimsy charges. They are being produced before a magistrate's court and before the lower court. But the lower court is not discharging them. So they are putting them in police custody and being jailed. And Mohammad Zubair was perhaps lucky in some ways that he had access to senior counsel, as everyone should, and as is his right, that he had access to that he was able to petition the Supreme Court to grant him bail. But I think the question that a lot of people might have is also, why is it that the lower courts are not, are actually giving in to the executive demand of saying, no, we need to investigate this person. So another case that sort of came to my mind was the case of Munawar Faruqi, the stand-up comedian, who was arrested for a joke that he didn't even make in a bar in Madhya Pradesh. Now, cases like this also sort of make people question the credibility of the judiciary, not just the Supreme Court, but also the lower courts, who seem to have a lot of power in terms of making sure that somebody can be in custody, even though the charges are flimsy, even though there is no evidence at that stage. So what I see in terms of the state of there is a dissonance between also judgments of the Supreme Court, constitutional bench decisions that protect fundamental rights, and what you may see at the lower levels or the lower courts, where that is not being applied, where due process is not followed, never mind substantive justice. But I think the other question I actually had for you, in terms of the legacy of the Indian judiciary and what you said about costs being imposed on petitioners, for example. I actually wanted to ask you where this hostility has come from towards, petitioners who approach the court to challenge certain laws or challenge the government, because this is a court. The Supreme Court has been a court since the 80s. I mean, that's when the doctrine of public interest litigation, famously people writing letters to the court and their cases being taken on the basis of a postcard or a letter. Where has that spirit gone? Why has it gone? Has it gone? And where is this extra sort of hostility towards petitioners coming in? It's one thing to dismiss cases and say, all right, there's no merit in this case, but it's quite another to encourage investigative agencies to go after petitioners or impose heavy fine on petitioners. So it's a sort of departure from what we saw of the Supreme Court as this kind of beacon of hope for people who have no money to approach it, who could approach it just by writing a letter, to what we're seeing today. And I wondered if I'd like to hear from you what your thoughts are on that kind of hostile environment that's being created, in these courtrooms.
So I'll answer your second question first. The answer is very simple. This is happening because the judiciary is clearly functioning with lack of independence and under the influence of the government, or at least sections of it. And we are seeing that. I mean, Arun Mishra, for example, in a public platform declared that Modi is a versatile genius who thinks locally, acts globally, or whatever, thinks globally, acts locally. So we are seeing this kind of fawning mentality of some judges towards the government. And when the government is a very strong and almost fascist government, in any case, there are many judges who are very fearful of crossing swords or crossing the path of such a strong and almost fascist government. But there are those who go beyond that. So they are even more loyal than the king, so to say. And these kind of orders that we have seen in Zubair's case, in Tista's case, or in this Chhattisgarh case of Himanshu Kumar, etc. I mean, these are judges trying to show that they are more loyal than the king, so to say. It's almost like that. And so far as your first question is concerned, why is the lower judiciary not acting to protect people or to grant bail to people or protect people against these clearly unlawful arrests? We are seeing people being arrested for putting up posters against the government. We are seeing people being arrested for tweeting against the government, and so on, which are clearly no offenses whatsoever. I mean, far from being any offense and of sedition, there's no offense whatsoever. So the job of the lower judiciary is to immediately say, look, I mean, this is a bogus charge. This is not an offense, putting up a poster against the government, and therefore there is no question of any remand that you are seeking. We are just quashing the case here and now. We are saying we are discharging them, and we are saying that this FIR is bogus. You have to, this FIR is quashed. But even if there was a charge, even if a person is arrested, like in the Bhima Koregaon case, they have made out a fabricated case, but they have made out some case. Or in the Delhi riots case, they have made out fabricated cases against most people, but they have tried to make out some case against at least some people. Against some people, there may be no case. But again, some people, there may be some case which they are making out, but even then it does not justify putting them in jail, because the law on arrests is very clear. You will not arrest merely because you are investigating some criminal offense against somebody. You will arrest if and only if one of these three conditions is present. One, that he, if not arrested, he is likely to flee from justice and will not be available to stand trial. Two, if not arrested, he is likely to tamper with witnesses. Three, if not arrested, that he has committed a very heinous offense. If not arrested, he will continue to commit such other further heinous offenses. These are the only three grounds in which you can arrest a person during investigation or even during trial. Even if a charge sheet is filed, even then arrest does not automatically follow, should not automatically follow. It should only happen because that person has not been found guilty, and he is presumed to be innocent till he is found guilty. And unless there are very strong circumstances to suggest one of these three things, there is no ground for refusing bail at any rate. Therefore, the lower courts should have followed this law, which has been declared by the Supreme Court in many cases, that bail is your right, jail is the exception. And of course, in many cases where there is no offense made out, the court should immediately quash the FIR, discharge the person immediately. But this is unfortunately not happening, and that the reason is that the lower courts are usually more under the influence of the local police authorities. This has been the general experience, and that's also because the police works to some extent closely with the lower courts, and therefore the lower courts are more under the influence. Lower courts also do not enjoy the kind of protection that High Court and Supreme Court judges enjoy. That means they can't be removed unless they are impeached. Lower court judges can be removed by, of course, by the High Court, not by the government, but they are also fearful of, because they feel, just as this judge in the Karnataka High Court said, that I was told that you'll be transferred. He was, of course, brave enough to resist that, but transfer is the only thing that you can do to a High Court judge. So far as the lower court judge is concerned, he can be suspended. So if he had been a lower court judge, he may have succumbed, because if that threat was coming from the High Court or from some High Court judge, that you better fall in line, otherwise you'll be suspended, or or this will be done, or that will be done. So therefore, this is a problem that we have with the lower judiciary. But certainly that there is no reason for the High Courts or the Supreme Court not to behave totally independently, because those judges are fully protected. And just merely because they are fearful of a fascist government, actually, this is a great weakness of character. If people just sort of crumble, or their independence crumbles because they are fearful of a strong fascist government, which is just trampling upon the rights of people, doesn't mean that the High Court and Supreme Court judges should sort of collapse because of this fear. But unfortunately, to some extent, this is happening.
I think a question that a lot of us also have is access to the Supreme Court, again, in terms of lawyers who can represent us. And what we're also seeing is that very few people seem to have that privilege of even accessing the Supreme Court, because there's multiple steps to that. I mean, you also have to get your case mentioned and then it is listed, so I mean, that sort of it requires a certain kind of person who has access to, say, a senior counsel, an advocate on record, and all of that, to be able to even get bail, for example. So, in terms of your understanding, for, I mean, for the audience as well, what what hope do a lot of people then have when, for example, you are arrested for a tweet? You are, say, a student in Thane in Bombay. You have tweeted something. You've immediately been arrested. You don't have access, that kind of access to the Supreme Court, perhaps. So what is it, I mean, how then do we keep up with that kind of hope that is required of a judicial institution? It is not just the content of the order, that, for example, you've been given bail, but maybe it took you 6 months to get bail because you did not have a lawyer who could make those arguments for you. So I suppose this is also something that, because this is something we've also seen in our research, in, say, sedition cases, for example, where a few people get to approach the Supreme Court and the High Courts to, say, have their FIR squashed, or to challenge other infirmities in their case. But most people do not have that, and they have to wait until default bail is granted under the CRPC, which is about 3 months. And in those 3 months, then again, there is, your education goes, you lose your job, you fall sick, etc., and many things can happen to you. And the reason I also ask this, because this quote that Justice Ramana has been saying in his speeches, the process is the punishment, and I think that's again something that we've heard a lot now. So if we agree that the process is the punishment, um, would access to the Supreme Court, or how would we imagine something like that in order to counter in some way the effects of being arrested immediately for a tweet? The least I can then do is at least have access to a good lawyer, but I don't even have that. So I suppose it's just it's both a question and a comment on the state of affairs. But it would be good to hear you talk about how you then imagine the future to look like, if these are the problems we have now.
No, these problems we have had since the beginning, and uh, these are very real and genuine problems. And many judges have believed that the answer to this is legal aid, but to my mind, legal aid is not the answer, not the solution to this, because you cannot really provide effective legal aid. It is impractical to think that you can provide effective legal aid to all the people who need legal aid in this country. As I said, the first and the most important problem with the judicial system is lack of access, because ordinary people cannot afford lawyers. Forget senior lawyers, they can't even afford junior lawyers or even lawyers at the local level. And that is why most people who are in jails today are under trials, because they have no way of even defending themselves, or no way of even seeking bail, etc. In fact, if a common man is just arrested by the police, his only recourse is to just fold his hands before the police or before the magistrate, and he can't really effectively defend himself or represent himself. I have always believed that we need to have an informal court system in order to allow the common people even to have access to the judiciary, where the rules of CRPC and CPC and CRPC need not be strictly followed. In fact, the Gram Nyayalayas were thought to be these kind of institutions for at least common, ordinary, and petty, both civil and criminal cases. But unfortunately, that act, though it is a 2010 act, this has not been implemented, and Gram Nyayalayas have not been effectuated. But that was the way to have gone, and which would, some paralegal help can be provided to the litigants there, so that they are able to narrate. When I was in the US, there used to be a program called People's Court. Uh, this was about 40 years ago, 35 years ago, almost 40 years ago. I believe that program was continued thereafter, where a retired judge was asked to come and decide cases. Actual cases were withdrawn from court and given to him for decision. Both parties agreed that they will abide by his decision. He used to hear both parties. He used to call both parties with their documents and witnesses. He used to hear them then and there, ask them whatever questions he needed to ask them, see whatever documents he needed to see, examine whatever witnesses he felt were necessary to examine, and thereafter decide the case then and there. That program used to be 1 hour long, and he used to decide 2 or 3 cases, hear them fully and decide them fully. I have seen that program at least on 20 occasions, and my father also saw it at least on 10, 12 occasions, and we both felt that almost perfect justice had been done to those cases. So A to Z, without the help of lawyers, the judges, of course, that judge was a very competent judge. He was a very intelligent judge. He was a retired judge of one of the California courts. His name was Wapner at that time. But I am saying that if you select judges who have reasonable intelligence, good common sense, and a sense of equity, there is no reason why such people, even if they do not know law to that extent, I have always believed that in order to select judges, you need to test them on intelligence, common sense, and sense of equity and fairness. And thereafter send them to a judicial academy for even a 1-year training is enough to equip them with enough legal knowledge so that they can preside as judges in these Gram Nyayalayas and decide these normal cases, both civil and criminal cases, fully and to the satisfaction of the people without the help of any lawyers. At best, some paralegal help can be required. So, to my mind, that is the way to go. This whole system has become too top heavy, too dependent. I mean, what to say of there are cases like the hijab case, for example. It's not even been listed for the last 5 months or 4 months. Not even the first listing has happened. There are many cases which have not been listed for 6 months or even a year altogether in the Supreme Court. I mean, we are seeing a virtual collapse. The only way in which you can get your cases heard is if you have an influential or a senior lawyer who can make a mention and get the case listed, etc. Otherwise, cases are not even being listed. This is, of course, a recent phenomenon which has happened since COVID came for the last 2 years or 2.5 years. But that other problem is an endemic problem, that most people do not have access to lawyers, what to say of senior lawyers, and therefore they can't get justice. They don't even have access to the courts.
I think we recently saw these figures released by Parliament on UAPA in terms of the number of acquittals and convictions, and how high the acquittal rate is in UAPA cases and how low it is, on conviction. And when you were talking about the lower judiciary and the selection of judges, it also got me thinking about the criminal trial process. I think a lot of the frenzy that we see, the quick arrest, the denial of bail, the executive access, is at the pre-trial stage. But at the trial stage, clearly there are the rigors of trial that are able, or the standards, evidentiary standards are high. Witnesses are supposed to be cross-examined. Experts are called in. Clearly, in a lot of these kinds of cases, whether it's UAPA or whether it's sedition, we're seeing very high acquittal rates. So in some ways, and the reason I bring it up is also the title of the talk is Hope and Despair, and that gives me a little bit of hope that the trial process is rigorous enough to say that the evidence that is gathered by the investigating agency and then presented by the prosecution is clearly failing the test laid down it's clearly not enough to convict. And we also saw this with, the acquittal of 121 Adivasis in Maharashtra by the NIA court. So all of this also sort of makes me wonder what then is, clearly trial courts or criminal trials are going the way they should go, hopefully, because we have a very high acquittal rate, which means most people are being found innocent. So what is happening then between the time the arrests are made on very flimsy charges? The evidence is then not able to withstand the entire trial process, and then you have such high rates of acquittal. So in some ways, I think I'm bringing this up only because, again, there's some hope clearly over here, but at the same time, it's coming a bit too late. It's coming at the end of a very long drawn out trial, maybe 10 years or maybe 15 years, at which point what do the petitioners do? So I think, again, the reason I bring this up is because we were talking of the lower judiciary and talking of how cases should be decided and how judges at the lower judiciary should be. So is this something you'd like to reflect on? I mean, just in terms of some of these laws where acquittal rates are extremely high, conviction rates are extremely low. So what is going on that so many cases are being filed, but such, more people are being sort of innocent and fewer people are being found guilty? So it's an odd sort of problem. There's a funneling down of, or so, yeah, I guess it'd be good to hear
So
from you.
the reason is very simple, that there are some laws like UAPA and sedition which are abused much more than the normal penal code. So people who are charged under UAPA are usually charged because the process that the bail is very difficult under UAPA, because UAPA is a law which says bail can only be granted if the trial judge records a finding to the effect that there is virtually no case against this person. So that is very difficult to record, and this Justice Khanwilkar in a recent judgment also said that at that stage you cannot even go into the admissibility of the evidence that has been adduced against this person. So therefore, UAPA is being abused much more than the Indian Penal Code. So is the law of sedition, and that is why in those cases acquittals are very high. But so there is no evidence against these people. It's a clearly bogus case, and the fact that they are acquitted shows that there is, yes, at least some degree, reasonable degree of scrutiny at the stage of the trial by the judiciary, by the trial courts. So, but there are also many cases where people are just being unfairly convicted because they are unable to defend themselves. Or sometimes, for example, in this case of the murder of Haren Pandya, High Court fortunately gave a very detailed judgment, uh, not only acquitting those people, but saying that the investigation was totally botched up by the Gujarat police. Totally botched up. It was a horrendous investigation with such glaring malafides in the investigation. And yet the Supreme Court has reversed the High Court judgment and convicted those people who I believe were totally innocent. So there are also many instances where totally innocent people get convicted wrongly, and the trial court that could be because these people were unable to defend themselves, and it could also be because the trial courts were being influenced by the prosecution or by the state. So but yes, you are right that the high rate of acquittal under UAPA and sedition, etc., shows that at least there is some degree of scrutiny at the level of the trial, at the stage of the trial, by the lower court. So that shows that to some extent or to a reasonable extent, even the lower judiciary is functioning.
Right. Um, I think, yes, I mean, to me, I think one of the reasons I picked that statistic is also because, like I said, there is this sort of confusion for why then, the charges are filed in a great hurry for a tweet. But, ultimately, we know that tweet will not sort of stand the rigors of a criminal trial and someone being actually held guilty for it.
That's
Um,
because the process is the punishment, so they know they don't care ki ultimately they don't even bother to see whether the person will get convicted or not. They've done their job by keeping him in jail for a few years. That was their job and they did it. So that's all. They've succeeded in silencing them, destroying their lives and so on.
So then, can I ask, do you really believe that the Supreme Court is genuinely then even invested in protecting people's rights? I mean, are they, because the other sort of phenomena we're also seeing is many oral observations being made, comments being made over the years about protecting free speech, but then those don't find their way into the order. Speeches being made outside, at various spaces by judges where they talk of all of this, but then we don't see it happen. So what is this mixed messaging that the court is trying to then, what sense do we as citizens make of that kind of mixed messaging? Are you not invested enough in protecting your citizens
So there are
as
two
an
things. You
independent?
see, one is that the Supreme Court is also not a monolith in the sense that there are many judges in the Supreme Court, and some of them are doing their jobs while many of them are not doing their jobs. So it all depends from judge to judge. But there is also another trend that we are seeing that while judges are very good in making remarks in various seminars and speeches that they give in different places, especially when they go abroad, etc., they like to sound very liberal and very pro liberty and pro democracy, etc. But when it comes to the crunch, when it comes to delivering actual judgments in actual cases, they often don't do what they profess or what they say in their speeches, etc. That's because it is easy to give speeches, but when it comes to the crunch, they have to stand up to the government. If there is a case in which the government is seriously interested, and if this government is a very strong and fascist government, then they have to be able to stand up to the government and risk supersession or risk uh, other things, etc. But there's not that much of a risk either. They can only risk supersession. So Justice Khanna risked supersession and gave a dissenting judgment. But there are many who don't want to even risk that. So therefore, so this is a problem that we do see, but we should not treat the Supreme Court as a monolith. There are many judges and there are many judgments. Even the same judges sometimes give very good judgments. For example, the same judge who gave the very good judgment in the Muhammad Zubair case, granting him bail and not prohibiting him from tweeting and protecting him from future FIRs also, that same judge in the Gyan Vapi Mosque case did not stop the proceedings of the lower court when it was a clear cut case where the proceedings of the lower court are totally illegal, are totally opposed to the Places of Worship Act. But so we also see this kind of thing. And I have always believed that, and I always practice it also, that I praise any good order coming out of the Supreme Court, which is pro liberty, pro democracy, etc., where the judge has demonstrated some independence. And I criticize, and I very strongly sometimes criticize, the bad judgments coming out of the Supreme Court, which are anti liberty, etc. And I feel that all citizens need to scrutinize the actions of the judiciary and need to comment boldly and fearlessly about what they feel and believe about their orders and their actions. Because that way you are likely to steer them to do the good things, to do the right things, to perform their duty under the Constitution, rather than succumbing to the influence of the government.
I feel like that's a wonderful way to maybe tie up this conversation in terms of what the public should be doing, or what our responsibility is, to make the judiciary see what they should be seeing, which we have sort of discovered here. They're not currently seeing what they should be seeing. But I think that's a great way to sort of wrap up our conversation. But are there any last thoughts you have on just what we should be looking forward to? Because as the title says, we are currently swinging between hope and despair, but we're all still in the pursuit of justice. So what should we as citizens continue to hope for from the judiciary, specifically from the Supreme Court? And
See, we always live in hope and we should not give up hoping. But we should be realistic in our assessment of, in understanding where the judiciary is today and what is happening. And that's not a very good position, unfortunately. We are seeing to a very large extent a collapse of the independence of the judiciary and a collapse of its functioning. So, therefore, but we must always continue to strive to somehow uh, put pressure, to build public pressure, to bring about the reforms that are required, to comment very, very independently, correctly, and fiercely on the actions of the judiciary, so as to steer them in the right direction, so as to make them perform their duty. So, therefore, we must not give up. We must not give up hope altogether, but we must be conscious of where we are and that we are in a serious situation.
I think yes. On that note, we can wrap up this conversation. And thank you so much for everyone listening in on this. It's been a pleasure to speak to you, sir. And I hope we can do this again.
Thank you, Lubhyathi.
Thank you.
Good night, everybody.